exactly.
But on page 2 of the CFJ 284, it recommends 12 months incarceration.
Those are the two issues.
All right, so Agent Fagan, which one of those is your recommendation, and can you change them both to be the same?
The 6 months, Judge.
Okay, all right, so we'll just change that 12 to 6.
Thank you very much.
All right, any other additions, corrections?
There are none. Thank you.
Okay, and the advisory guidelines in the new file, the home invasion file, is 0 to 17 months. In the probation files, shoot, the only one that really matters is 6891 is 51 to 170 months. Any scoring challenges?
I do not find any challenges to the scoring.
Any additions, corrections, or scoring challenges from the people?
Your Honor, part of the plea agreement was restitution in the amount of $300. That was not carried over to page 3 with the recommendations. So I just asked that be carried over.
Oh, okay. All right, anything you want to say on behalf of your company?
Your Honor, even when I read through the PSA, there was one thing that it stood out to me that said, she blamed others for what has happened to her. And at least with my conversations, and granted my situation with my client's different than most other people, but she has always, in all these files, I've been the attorney with her, has always said that she was at fault, and that she's always had a culpability when I've had conversations with her. So when I read that, I was a little perplexed by that, but that's maybe how she came through in the interview. However, I had not seen that. And I think that was something I need to point out to the court, that even with this last issue, when she knew with the home invasion that was going to terminate her from the recovery court. And I think she was making progress in the recovery court, at least gaining some tools. However, implementing those tools when you're not in a structured environment is a lot different. And obviously, she did not do what was quite right that night with this home invasion, which put the recovery court into a situation where they couldn't have her any longer because of that type of activity. And right from the initial meeting with her, she understood that. And again, like I said, I haven't seen where she blames others or is not accepting responsibility. And I would ask the court to possibly depart down in this case from what's the guidelines say. She understands she's going to do a prison term, and we know that's coming. However, I would ask that the court consider the minimal amount that the court seems or deems fair. Thank you.
Well, thank you, Mr. Gilbert. Ms. Armbruster, is there anything you want to tell me today?
Yes, Your Honor. I want to say thank you to you and the rest of the recovery court team for another opportunity to better my life and make an honest effort at working on my recovery. I did complete an extensive rehab program through Harbor Hall and have been clean off meth for 8 months. My family and friends did notice big changes in me, and for that I'm so grateful. After leaving treatment, however, I did realize I don't just have a drug problem, I have a trauma problem. Until I can heal my past traumas, I won't be able to adapt to the honest recovery program I want for myself. I want to also apologize for the negative effect my addiction has had on the community. In my addiction, I not only hurt myself, I let down and hurt the people who care for me and love me the most. And some are forced to make hard decisions and set some serious boundaries with me. It's unfortunate that this day has come, but I know God has a bigger plan for me. I have a good mindset, and I'm looking at it as an honest opportunity to focus on myself and make positive changes towards the life I want, so I can come out being a sober, productive member of society again. Thank you.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant has 7 felonies at 31 years old, and looking at the timeline, she committed her first felony only 5 years ago and 6 more after that, which is a short time frame. She's committed this additional crime while on probation for others, as well as the violations that she had in a short amount of time that she was in recovery court. She previously has served 2 jail sentences, 4 terms of probation, so services have previously been offered, as well as the current attempts for recovery court and the prior attempt for recovery court. Given those circumstances, I don't believe the low end of the guidelines are appropriate. However, it would be her first prison sentence, so I don't think high end of the guidelines either are appropriate. I request the court to order somewhere in the mid-guideline range. Thank you.
Thank you. Well, Ms. Armbruster will handle the new file first, 25-6984. You're here for sentencing on an attempt, home invasion third. Oh, Agent Fagan, I did have one change in that report. The statutory maximum for the attempt remains 5 years. It changes the grid, but the statutory maximum remains the same at 5 years. If you could make that change. Anything to be heard from the defense on that question?
No, I would agree.
From the people?
I would also agree.
All right. The advisory guidelines are 0 to 17 months. Those would typically call for an intermediate sanction without incarceration unless there's reasonable grounds to do so. Here, there is reasonable grounds for incarceration in that you committed the offense while you're on probation, and not just a probation, but in the recovery court program. And, this was the second time that we let you into that program, and the second time that you've not successfully completed it. And that was, I'm sure, a disappointment to you. It's a disappointment for us as well. When we decided to take you back into the program, it's because we wanted you to succeed. We don't have anybody come in wanting them to not succeed at it. What's troubling here is that while you're in intense supervision, you're still engaged in felony conduct. And even when that was initially charged, the original charge is for home invasion third degree. The way the home invasion statutes are written, those facts would have also supported a first degree, which is a 20-year Class B felony. And you could have been looking at a lot more time as well. So I think, through the charging decisions and through the plea bargaining process, you've certainly been treated very fairly about the situation. I do think that that given that you committed that while on an intensive probation, that I am not going to follow that recommendation. This obviously won't be the case that drives the bus. We'll get that in a second. But on this case, the 6984, I'm going to order that you pay a state cost of $68, crime victims assessment of $130, and $300 in restitution. And I'm going to commit you to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 5 years, with credit for 121 days previously served. And that is a sentence within the advisory guidelines with the reasonable grounds for incarceration being placed on the record. Do the appeal right to the end on all. All right, and in the probation matters, first in file 24-6814. That's you're on probation for possession of methamphetamine with the drug double. Advisory guidelines at 0 to 17 months. In that file, I'm going to follow the recommendation and revoke your probation and order that you serve 140 days in jail with credit for 140 days previously served. Any fines and costs that were assessed remain due and owing in the amount of any unpaid balance. So in that probation, it's revoke, discharge unsuccessful, and time served. In file 6862, that's possession methamphetamine drug double and a use of methamphetamine drug double, the advisory guidelines of 10 to 23 months. I'm going to follow the recommendations in that file and revoke your probation, discharge you as unsuccessful, and order that you serve 205 days jail with credit for 205 days previously served. Because it's a straddle cell, the court can impose an intermediate sanction with incarceration. So that's not actually a downward departure. Any fines and costs assessed in that file will remain due and owing in the amount of any unpaid balance. So again, Ms. Armbruster, that file will be revoked, discharged, and time served. And then that brings us to file 24-6891 FH. That's a charge for delivery of methamphetamine habitual forward. And the advisory guidelines are 51 to 170 months. You were, that was your second time into a drug treatment court program, a problem-solving court, trying our very best to avoid sending you to prison. And then while you were in that program, you engaged in new felony conduct that was a crime against a person. So it's appropriate to revoke your probation and discharge you as unsuccessful in that matter. Any fines and costs that were assessed remain due and owing in the amount of any unpaid balance. And so we have to decide, you're obviously, as you know, going to go to prison today, and the question is for how long. Then the advisory guidelines are 51 to 170 months. This is your first prison commitment, so I don't think that an upper end is recommended. But here I have to take into account, even though I've given time served on the other files, there were a number of different felony cases going on. And then while I've got you on probation for a treatment court, you're engaging in more felony conduct despite the real close supervision. And we were really engaged with you. I thought we saw, the first time you came through, you had kind of a really rough edge to the attitude. And the second time, I thought we saw some chinks in that armor and some sincere willingness to engage in the services. But you weren't able to control your conduct when you had a disagreement with the victim in this case. And so I think all those things into account, a sentence on the lower end is appropriate. The recommendation from the Department of Corrections fits the bill. It is measured and proportionate. So I'll commit you to the Michigan Department of Corrections for not less than 60 months, nor more than I'm going to exercise my discretion. There is a habitual forward to increase the statutory maximum to 30. So it's a 5 to 30 year commitment. You're entitled to credit for that one has
I believe it was
122 days credit. And that is a sentence within the advisory guidelines. I do think it's proportionate to the seriousness of the circumstances of both the offense and the offender. All those sentences will run concurrent with each other. All right, so Ms. Armbruster, you can file an application to appeal if you want in any of those 4 files. If you wanted a lawyer, I would certainly give you one. You'd have to make that request within 6 months. So we're going to hand you 4 sets of these appeal paperwork. There's 2 copies in each one. We're going to ask you to initial 1 copy in each one, so we have a record that we gave it to you. And the other one is for you to fill out if you do want to take an appeal. Do you have any questions for me about any of that?
No.
All right, Ms. Armbruster, I know this seems like a very long tunnel, but this, I assure you, is going to go, it might not go that fast, but it will go. And so you'll be back in our community. It's still a very young age and still have many choices to make, both when you're inside and when you're back. So I hope when you're back, you stay on a better track, because now with this record, if you have more felony conducts, we can't go low end of the guidelines anymore. And you see from these guidelines, if you on parole engage in more felony conduct, it's going to have to be a really long sentence. And I certainly hope that day doesn't happen, Melissa. Good luck to you.